You sued your doctor for medical malpractice and your case goes all the way to trial. What happens as your case is getting closer and closer to trial when your attorney calls you up and say, hey, listen, we've got a problem. Our medical expert who supported your case has now backed out and now refuses to come in and testify. What happens in that case? You want to know the answer? Come join me on this walk through the neighborhood as I tell you exactly what happens. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Don't think this doesn't happen. This does happen occasionally, where for whatever reason the expert now refuses to come in and testify on your behalf. Remember, in these medical malpractice cases here in New York, we are required to have a medical expert confirm that number one, your doctor was careless, number two, that his carelessness was a cause of your injury. It doesn't have to be the cause, it only has to be a cause. And number three, that your injuries are significant and or permanent. All three of those things must be confirmed by a doctor who's either treated you or reviewed all of your records. If any one of those things is not present, guess what? We can't go forward with a case on your behalf. So now let's assume you've already had your case reviewed by a medical expert. Now we go forward, we start a lawsuit on your behalf. And now throughout the litigation process, we know that this expert has confirmed that you have a valid basis for a case. In fact, during the course of discovery, we provide your medical expert, our medical expert, with additional medical records as well as the testimony, pre-trial testimony that you have given and other doctors have given in order to get his updated opinions on your case. And throughout the entire time, this medical expert has confirmed again that yes, you have a valid basis for a case, with the obvious expectation that, listen, if he confirms that you have a good case, that if your case goes all the way to trial, this will be our expert who comes in to testify on our behalf. So now, what happens? The defense refuses to negotiate, which means your case is going to trial. So now, in preparation and getting your case ready for trial, one of the things we have to do is get in touch with our expert, update him on any medical records that came in, update him on recent information, things that have gone on recently, and now I have to go ahead and sit down with him and prepare him for trial. And there are different ways to do that. But one of the key ways to do that is to meet with him face to face and now review the records in detail and review the types of questions I will be asking him as well as the type of questions he can expect to get during cross-examination. I call your expert up to let him know that your case is definitely on for trial next month. And what does he tell me? He says, listen, I'm sorry, I just changed jobs. There is no possible way I can come in and give testimony on your client's behalf. I say, what? Doctor, you've been our expert for the past 2 years. Now you're telling me 1 month before trial? Now you're telling me you can't come in and support our case? Is that because anyone has exerted pressure on you to tell you that you can't testify in this case? No, no, no. It's just an awkward situation. I don't want to let them know I'm testifying on behalf of a patient because it would certainly screw things up with my new employer. So now we've got a problem. No matter how much cajoling, no matter how much encouraging I do, the doctor now refuses to come in to testify. What does that mean for you and your case? Well, that could be devastating. In fact, it is devastating because now we've already exchanged this doctor's credentials and what exactly he's going to be talking about with the defense. I've already let the defense attorneys know that this guy is our expert without actually naming him. I've told them what our expert's credentials are and what he's going to be saying when he gets into court to testify. So now if I learn that our expert is no longer able to come in and testify, you know what that really means? It means we can't go forward with your case. We can't go to trial. Why is that? Because the law says in New York that in order to go forward to trial, we must have a medical expert who testifies on your behalf. An expert who confirms that yes, your doctor was careless, that yes, his carelessness was a cause of your injury, and yes, your injuries are significant and permanent. It's not enough to simply bring in a treating doctor of yours to talk about the problems you have now. No, instead we need a doctor to comment and critique the care and treatment that you received from your original doctor and how you developed and got all these injuries to begin with. That's what we are required to do. So what actually happens if we don't have a medical expert and we go to trial? The reality is the judge will dismiss our case. We could make opening arguments. We could go ahead and start taking testimony and question the various doctors. And now, when we're done with those witnesses, and now we have no other witnesses to question and no other evidence to present, I am obligated to tell the judge, Your Honor, at this time the plaintiff rests, which means we don't have any more evidence to produce. Now, when the defense hears that, they are immediately going to stand up and ask the judge to dismiss your case. Why? for failure to bring in a medical expert to support our claim. And you know what the judge will do? The judge will agree. He says, "Counselor, if you don't have a medical expert, I have to dismiss this case." And the judge would be well within his right to do so. So what does that mean for us? It means if your medical expert has told me a month before trial, "Listen, I can't come in and testify," now I actually have to scramble. I have to try and find another medical expert to review all of your medical records, and in a rush fashion, get him to review this quickly, to then give me an opinion, and it's only if he gives us a favorable opinion can I now use him. The moment he reviews the records and tells me, yes, we do have a valid basis for a case, now again I have to notify my opponent that we've gotten another expert, or a new expert, who we anticipate calling in to trial. And now this gives them an opportunity to do their research, to find out more about this expert, to learn who he is and what he's going to say. So, is that a problem? Yeah, it could be a big problem. As another alternative, as a last-ditch resort to try and save your case, I can ask the judge to mark your case off the trial calendar with the expectation that we will put it back on the calendar within a year once we get another medical expert. So that does two things. One, it gives us additional time to go ahead and get a medical expert, but at the same time, it also alerts the defense to know that we have a problem with our current medical expert, and that's not something I'm eager to share with them. So why do I share this great information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases here in New York, because this does happen from time to time. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit and are thinking of doing so, what I encourage you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.